Good morning. Do we have all counsel with us?
Yes, Your Honor. This is Bridget McDonald.
Would you like to turn on your video, Ms.
Yes,
McDonald?
yes,
great.
Good morning, Your Honor. This is Michael Radin of Victor Smith Law Group, counsel for the appellant.
Great. Welcome to this oral argument session of the 6th District Court of Appeal. My name is Judge Joshua Mize. I also have with me Judge Petra Brownlee and Judge Roger Ganem. I'll be the presiding judge today. This is being broadcast live on YouTube, so please do be aware of that. We have one case on the docket today. It's 23-587, White Sea Cattle Company versus Florida Fish and Wildlife Conservation Commission. Mr. Radin, how much time would you like for rebuttal? The default is 5 minutes, but we can adjust that if you would like.
First off, Your Honor, if you don't mind, how much time do we have altogether? Is it still 20 minutes like it used to be?
20 minutes each side, sir.
Your Honor, I'll waive rebuttal.
Okay, there'll be no rebuttal time, then set the clock for 20 minutes. Mr. Radin, please proceed.
Thank you, Your Honor. May it please the court. Let me first apologize to you that the 3 worst grades in law school were administrative law, but I've enjoyed the education. One thing that stood out about this proceeding today, sir, is that the court has advised us what issues they find the most interesting, and that's great. I really appreciate that. I don't know that.
Yeah, and I appreciate you noticing that, counsel. And obviously we set the oral argument. The parties didn't request it, so clearly we have questions. And I'll just get right to it. I'm not convinced we have jurisdiction over the case. I read both of the jurisdictional briefs, and at least without more, they both left me with serious doubts as to our jurisdiction. Obviously the Constitution says that district courts have direct review of administrative action as prescribed by general law. So in order for us to review administrative action, there must be a general law prescribing us jurisdiction. The Administrative Procedures Act grants jurisdiction for administrative review of final agency action, but it defines agency action as an agency acting pursuant to its statutory powers, or I think that's powers granted other than by the Constitution. And there doesn't seem to be any debate to me among the parties, and it makes sense because it seems correct, that this fencing requirement was adopted pursuant to the Commission's constitutional authority. And so the APA just seems not to grant us review over that. I read the Commission's brief, and the Commission's jurisdictional brief basically said, well, but we've adopted the APA for our procedures, and that includes the provision allowing for judicial review. The problem is the Commission can't pass general law. It can't pass statutes. It can adopt, if it wants to use the language of the APA for its due process procedures, it can certainly do that, and it does. It cannot grant us jurisdiction because it cannot pass general laws. So the Commission's brief did not convince me we have jurisdiction. And your brief seemed to wholly ignore the issue. I mean, our order regarding the jurisdictional briefing was really explicit as to why we had a question about jurisdiction. And your brief really, I think we put in the order, identify the general law that gives us jurisdiction. The Commission identified the APA because they've adopted it, which I said I think is wrong, but they did identify one. Your brief didn't identify one. So I guess that's my first question for you is give me a statute number. What is the statute number in the Florida statutes that gives us jurisdiction over this case?
If I may, Your Honor, just one observation about the Game Commission's argument. We have not ever contested the existence of this rule, nor their authority to promulgate this rule. And I think their reliance on the Airboat Association case is misplaced.
Counsel, when I ask you a question, I want your response to be the answer to my question.
Certainly, Your Honor.
Yeah, I have asked you for a statute number. The Constitution says there must be a general law giving us jurisdiction. That means you should be able to say, Judge, it is Florida statute section number this. Please give me the section number of the Florida statutes that you believe gives us jurisdiction.
120.542, sir. in addition to the APA in general.
Okay, which subsection of 120.542 do you think gives us jurisdiction?
I don't have the particular subsection in front of me, sir, but this is
Because I don't see any provision in 21.542 saying a district court of appeal has jurisdiction over anything. I know that's the portion
Your Honor,
allowing the commission
I
to have
won't
variances.
waste
and weight.
your time, sir. It doesn't have the word jurisdiction in it.
Okay. Can you give me a statute number that says district courts of appeal have jurisdiction over this type of action?
District court, I cannot give you a number, sir. My argument is that district courts of appeal have jurisdiction over agency actions on administrative hearing.
How? You can't just make the assertion. The Constitution says we have jurisdiction when prescribed by general law. If you don't give me a law, that means there's no jurisdiction.
I will not waste your Honor's time.
Okay. All right. I appreciate the candor. Would you like to address any other portion of the case?
Notwithstanding my ignorance, I just point out that the statute is a general, strikes me at least, is a general command to agencies to acknowledge that occasionally the application of a rule can be onerous to the point where it almost approaches a taking. And again, sir, it does not have the word taking in the statute, but that's the point that I perceive, that if a rule is applied arbitrary manner, or if a rule is applied that under the unique circumstances of the case, it would cause undue harm and expense to the party.
Well, counsel, I get your rationale about 120.542 and the reasons the legislature put it in there in terms of not wanting regulations to be inflexible that are promulgated by agencies to affect the legislature's statutes. Problem is that to find that 120.542 is just generally applicable to agency action, including constitutional agencies exercising constitutional authority, just ignores the language of the statute, which defines agency as only agencies acting not pursuant to constitutional authority. So how do you get around that? And I understand that you're saying, well, it'd be a taking otherwise, but it's not like we have to interpret a statute so that, or a rule, the agency's rule to avoid a taking. If it's a taking, you've got a taking action, right? There's no canon of construction that says statutes can't be construed to require a taking. It just means that if you've got a taking, you've got to go sue for takings, doesn't it?
Well, Your Honor, I would like to think we could avoid putting both parties through that at post-appeal proceedings, but what I guess I got hung up on, sir, was the Game Commission's reliance on the Airboat Association case. That's the one that most clearly states that the appeals courts cannot reconsider the official actions of administrative agencies. However, as I read that case, this was the promulgation of a rule that restricted hunting rights in the Big Cypress Swamp, and the airboaters tried to challenge it through an appeal. And that was the crux of that case, is the decision to restrict the hunting and use of airboats, etc., in the Big Cypress Swamp was totally within the power and discretion of the Game and Fish Commission. But we're not challenging the fencing rule. I think they would have a stronger argument under the airboat case if we were saying you can't enact this rule. You cannot impose this rule upon us. Our case is different, where they have exempted the client from the rule for years and years and years, and all of a sudden apparently changed their mind, and we tried to get a hearing.
Well, counsel, I get that this is not the airboat case, right? And I agree with you. It's not the airboat case. You're not challenging the rule and their authority to promulgate it. You're saying you're entitled to an exemption. To do that, you'd have to show us why 120.542 is applicable, right? It is a different case, but that doesn't mean you're right. So 120.542, the statute is explicitly defined to include agencies when not acting pursuant to constitutional authority. So how do I find that 120.542 applies to an agency exercising constitutional authority when it explicitly says this does not apply to agencies exercising constitutional authority?
Your Honor, all I can say is I expect that you and I have approached it two different ways, and I'm not sure how to answer you other than my
Is there a
understanding.
way is there a way to approach it using the language of the statute that leads your client to succeed on that point?
Well, my recollection is that the statute itself specifically applies to Game and Fish Commission. And
Well, it applies to all agencies when not acting pursuant to constitutional authority, right? That's, I think, 120.52(1)(a), right? I mean, so yeah, it would include the commission when acting pursuant to statutory authority, but it defines agency to mean agencies not acting pursuant to constitutional authority. And you haven't disputed that this rule was promulgated pursuant to constitutional authority.
the rule, no, sir, we're not. And but I think that you and I may have a different concept of constitutional authority. They have the constitutional authority to promulgate them. They've granted us an exemption from the rule for years and years, and then they just changed their mind. We asked for an administrative hearing, and we did not get a full hearing because they would not entertain our argument that and wouldn't even permit us to present evidence, as I recall. Now, sir, I was not at that hearing, so my memory of it is not, it's from reading a transcript, but that they would not entertain any evidence that applying the rule to Lightsey would be onerous. There is a difference. Suppose that Lightsey today decides we want to run a game preserve, and they go to the Game and Fish and say, what do we have to do? And they say you have to fence your entire property. Well, we can't, it's an island. Well, too bad, so sad. We wouldn't be having this conversation, Your Honor, because that was within their constitutional authority. But in this strange circumstances in this case, they have granted an exemption for at least 20 years and wouldn't even necessarily, I don't think that the final order even makes it clear whether they even accepted that they had granted an exemption.
Well, what the final order said, how I read it was, we don't have to decide whether an exemption or a variance or a waiver was granted because as a matter of law, the commission has no authority to grant those. So it was a legal matter. It just could not have been granted. So those, whether or not you think that some document looked like that was not a material dispute of fact, maybe a dispute of fact, but it's not material because as a matter of law, there's just no authority to issue an exemption. So whether or not it was written on a piece of paper, it just legally could not be an exemption. And to me, there's two arguments here. There's one, are they right that they're not able to issue an exemption? And that's 125.4.2. And it seems to me that that does not apply. And then there's your estoppel argument, which I think it sounds more like what you're getting into. And if you want to move on to the estoppel, that's fine. But is there anything? I'm taking your argument as a concession that the language of 125.4.2 on its face does not apply here. Do you have any reason why that is wrong?
If you look at it like, does that section specifically say in it that the Game Commission is subject to this requirement? No, it doesn't say.
Well, that's not what I asked you. Is there any argument based on the text of the statute? Is there any text you can point me to which would indicate 125.4.2 applies here?
That it applies to the Game Commission, or
that it applies to the Game Commission when enforcing a rule enacted pursuant to constitutional authority, given that the statute says it doesn't apply when they're exercising constitutional authority. Is there any language I'm missing? Any reason you'd like to point me to in the language of the statute why 125.4.2 applies? Any reason at all?
I don't want to beat a dead horse, sir, but other than the fact that the statute itself opens with the observation that sometimes inflexible enforcement of rules can be onerous and unwarranted. And again, the exact language I don't have, but it's like the very first part of the statute. But that's the best I can do, sir.
Okay.
Counsel, can I ask you, just so that we're perfectly clear on this, that you completely agree with what Judge Mize has asked you and asserted that this rule was no doubt made pursuant to, well, I'll dub it an agency just for purposes of this question, but pursuant to the constitutional authority that it has rather than statutory?
You are asking about the fencing rule, Your Honor?
Correct.
I've never disputed that they have the constitutional authority to.
Not that they have the constitutional authority. That's the purpose of my question, because when you answered this for Judge Mize, that's what you stated as well, that they had constitutional authority to do it. Are they acting in your mind pursuant to that constitutional authority through this rule, or were they acting pursuant to some statutory authority that they might have? Because if it's a statutory authority, then you might be in a different position.
I'm not aware of a statute that says you have to fence game preserves. I would say that's their call. This is a business that could, under certain circumstances, at least pose a great hazard to the surrounding area. So they're entirely within their discretion to adopt this rule. I sense I'm not answering your question, man.
I think what Judge Brownlee meant, if I may, is that say the commission had constitutional authority, but there was also some statutory regime relating to fencing, right? And that they actually enacted this rule pursuant to the statutory regime rather than pursuant to their constitutional authority. Judge Brownlee, did I get it right?
Yes. I'm trying to figure out if there's no doubt in his mind that this was done pursuant to constitutional authority, because as I see it, he's in a very different position with regard to jurisdiction. If that's true.
I'm not aware of a statute that says they have to do that.
I mean, am I correct that there are some, it seems to me that it's enumerated when the agency is acting pursuant to statutory versus its constitutional authority. Would you agree with that? I think it's in the Florida Administrative Code. That there are enumerated instances when it's acting pursuant to different authority that it might have.
Well, it may well be, Your Honor, but again, I'm not aware of any statute that I could point the court to say, when you decide to fence game preserves, here's your statutory authority to do it.
Okay, thank you, counsel.
Well, that's the best I can do. I'm sorry, man.
I appreciate that. That's okay.
Back to Judge Mize. I don't know how much time I've got left. I've got about
3 minutes and 45 seconds.
Insert. I mean, the issue of estoppel in general is covered in the reply brief, but therefore I focus more on what I thought was the adequacy of the administrative hearing. But the elements of estoppel: a material factual representation by the state contrary to a later asserted position. That's the first element. At one point they said you don't need a fence. Now they've changed their mind. Reasonable reliance upon that representation is that Licey Cattle Company has operated this preserve 20-something years, with the understanding that there are fences on the island, but the perimeter of the island is not fenced. And then detrimental change in position by the agency making the original representation. Original representation is you don't need a fence because your preserve is on an island completely surrounded by Lake Kissimmee. Licey relies upon it, opening up the game farm, soliciting clients.
Also, would the representation there be you don't need a fence, or would it be we've granted you a variance? Because you don't need a fence to me seems a matter of opinion. We're granting you a permanent variance or waiver from this requirement seems to me a representation of fact, like whether or not the agency had the authority to issue a variance, like just pretend it was clear, right? That they had no authority. Everybody agrees 125.2 doesn't apply. They don't have authority to issue waivers, but they nonetheless mistakenly give you a piece of paper that says, this is a waiver. You have a permanent, irrevocable waiver of the fencing requirement. So they would have acted illegally, right, or without authority to do that, but nonetheless, they would have made the representation to you that you have a waiver.
Well, that's what we think they did.
Okay.
And then it went on for years. This to me is significant too. It went on for 20-something years. They never complained about there being no fences, and Licey set up the preserve accordingly. And then all of a sudden, for And I suspect, and it's mentioned it's mentioned in the proposed order that we submitted to the hearing officer that did not adopt, but that there was somebody complaining about buffaloes and whatnot swimming off the island, and there's absolutely no evidence of it. Maybe that's why they changed their mind. But again, if that is why they changed their mind, they should have said so at the hearing. They should have presented evidence. Other than that, 20 years, we've invested in doing it this way. We got clients, successful operation, without having to spend, I think they estimated $1 million to fence this place. All of a sudden, it's out of the blue. That's why I think they should be stopped from enforcing this rule that they've not enforced for 20-something years.
Okay.
18 seconds. Thank you. I'm sorry I'm not a little more articulate than I appear to have been, but I appreciate the opportunity to appear before you.
Judge Brownlee, Judge Ganem, any further questions for Mr. Radin?
No, thank you.
Okay. Appellate's counsel, let's put 20 minutes on the clock.
Good morning.
Go ahead, Ms. McDonald, please proceed at your convenience.
Thank you. May it please the court. My name is Bridget McDonald, and I represent the appellate, the Florida Fish and Wildlife Conservation Commission. Let me first address, Judge Mize, your question on jurisdiction. So the constitutional provision that establishes the commission requires that the commission provide adequate due process in its executive and regulatory functions. And so to that end, the commission has adopted its due process rule 68-1.008 Florida Administrative Code. And specifically within that rule, it provides that for matters involving substantial interest, the commission has adopted Chapter 120, and specifically 120.57. So hearings involving substantial interest. In this matter, this was a hearing determined that there was no disputed material fact, and the informal proceeding was held under 120.57 subsection 2. And so then review of those decisions, matters involving substantial interest, then is provided to the court before this court by 120.68 and then subsection 2.
I get all that, counsel. I read your brief, and I certainly understand the commission is free to adopt, portions of the APA to govern its procedures. That doesn't make those general law, right? I think you would concede the commission cannot enact general laws, right?
Yes, Your Honor.
So you saying we adopt 120.68, you can't grant us jurisdiction. I mean, what am I missing?
Well, I believe we're adopting Chapter 120, and then the review of that proceeding is provided.
Correct, but that doesn't make your enactment of 120 a general law.
No, sir. Well, Your Honor, the commission has to provide due process procedures, and this is the function that the way that it is achieved. That function is by adopting Chapter 120, and so for these decisions that are coming out, and it could be from the Division of Administrative Hearings that were a formal proceeding, as well as from an agency's, and through an agency's final order, review is then sought in the appellate district.
I know it's been that way in other cases. I'm just questioning whether it was correct, because our jurisdiction is set forth in the Constitution, right? It's
Yes.
not, that can't be changed by anyone. Absent a constitutional amendment, and it says it's got to be general law, right? So I understand when you enact the section 120, the analogy I would use was, we have state rules of civil procedure, right? Say the federal rules purport to govern federal courts, right? They don't purport to govern state courts, and obviously there'd be constitutional issues there if they tried, but just on their face, the federal rules say these govern federal courts, okay? Imagine if instead of having state rules of civil procedure, instead of having our own rules with our own text, our rules just said we adopt federal rule numbers, 36, 52, and 47. Okay. If somebody filed a lawsuit in state court using those rules, they wouldn't be acting under the federal rules. They'd be acting under state rules. And it would just so happen that the state rules incorporate the text of the federal rules. it wouldn't turn those state rules into federal rules, and it wouldn't mean that somebody filing a lawsuit and a Florida Circuit Court was actually acting under the federal rules. They would just be incorporating by reference the text, right? It wouldn't turn state rules into federal rules. And I kind of think it's the same. You all are free to adopt the APA for your due process procedures, but the commission has no authority to give us jurisdiction. Like, what if you had adopted a rule that said circuit courts have jurisdiction or the Supreme Court has jurisdiction, right? Like, you have no authority to do that, do you?
No, Your Honor. I believe it's in the, and maybe airboat might be instructive for that. It's in the structure of the review provided through the courts. And so the review of these substantial interest proceedings is on appeal then to the district courts of appeal as provided in 120.
I don't dispute that people have taken jurisdiction before. I'm saying they were wrong. And if you think they were right, I need to hear not that another DCA has done it, but that here's why they had the authority to do it. Here's why they were correct to do it. And I'm reading the Constitution, and it says we have jurisdiction when there is a general law. We can review agency action as prescribed by general law. That means to review agency action, there must be a general law saying we have review. You've given me 1.12068, which does not grant us review because it only applies when the commission is acting pursuant to statutory authority, which everybody agrees you're not. You're acting pursuant to constitutional authority. And what you've responded is, well, we've adopted 120.68. And I guess my response is, the commission cannot adopt general laws. You adopting it doesn't make it a general law. So how do we have jurisdiction? Saying another case did it doesn't do it for me. I need to hear why that case was correct and how that satisfies the Constitution.
Counsel, can I ask maybe the question a little differently? It would be helpful to me anyways. Understanding that the defense rule derives from the commission's constitutional authority. Is it the commission's position that once that the commission's decision to put conditions on this permit in accordance with defense rule, that once that decision is challenged, that for purposes of hearing the challenge and adjudicating the challenge, the commission becomes an agency for purposes of the APA because it is acting pursuant to the statutory procedures, such that the agency action that we're being asked to review is statutory agency action that's procedural under the APA, as opposed to the actual rule itself that derives from the constitutional authority. In other words, can the commission be both a constitutional entity whose decisions can't be reviewed under the APA, but it can step into the shoes of an agency or sort of become an agency for purposes of our jurisdiction because it's applying these statutory procedures? Is that the position of the commission?
Yes, Your Honor. And I do believe that there's a distinction between considering the constitutional promulgation of the fencing preserve rule and vis-a-vis the argument toward 120.542, and then also as well providing separately under the commission's due process rule, that's providing the procedural statutes that are governing the administrative proceeding itself. And so, sir.
Judge Mize, if I could just follow up. So would, under that view, if rather than the procedural aspect or the decision not to provide a full evidentiary hearing, let's suppose that full evidentiary hearing had been provided and the commission decides to uphold the conditions on this permit, and then Light Sea Cattle comes to us to challenge the merits of that decision to uphold the fence rule, would that be final agency action as action by the commission under statutory authority, or would that be action by the commission under its constitutional authority, putting it outside the APA?
Your Honor, we believe that it would be the agency action under the statutory authority and through that process that's provided through 120 to review that decision.
Let me ask a question, counsel. You all adopted the APA. Say you hadn't adopted the APA, say you just written your own rules. Would you still be acting pursuant to statutory authority when you used your own rules to adjudicate procedures?
No, Your Honor, I believe then we would be using constitutional authority.
Okay, so it's statutory. So you didn't have to adopt the APA, and the APA on its face doesn't apply. But because you adopted the APA, when you could have written anything on your own, it becomes statutory authority?
Yes, governing the proceeding itself.
Okay. So I guess you're saying that I mean, it sounds to me like you're saying that you all can adopt statutes.
Your Honor, sorry.
It sounds like to me like you're saying that the commission can enact laws, can enact statutes.
Your Honor, I believe what the commission has done through its constitutional authority is adopt the procedure. And if I can briefly make a distinction, maybe using airboat to elaborate the distinction between 120.542 and really 120.56, which allows for rule challenges. In those both cases, rules that are promulgated under the constitutional authority of the commission, in this sense, they are not, the authority for it is not derived from the legislature. There's not a grant of rulemaking authority or an underlying statute that to implement in this case. And so the agency rules, in this case, the fencing rule, doesn't allow for any kind of variance or waiver. And then I think an important consideration as well is that violations of the fencing requirement and other constitutional rules do carry actually criminal penalties. And so in this instance, the 120.542, you maintain this position that, interpretation of the constitutional authority and the plain language of 120.542, that it would not apply to constitutional rules. It does apply to obviously the statutory rules that are derived from statutory authority that the commission.
Well, no, I get your argument at 125.42 and that you've adopted certain provisions of the APA. I'm having a hard time accepting that because as a jurisdictional matter, that because you adopt certain sections of the APA, that then you're acting pursuant to statutory power, because like you just happen to basically say we incorporate the text of the APA into our rules. That doesn't mean your rules are the APA. That doesn't mean your rules are statutes. You could have not adopted the APA and just written fresh rules. You just chose to adopt the APA. That doesn't seem to me to make it acting pursuant to statutory authority. And then on top of that, the APA doesn't actually grant power. I mean, the language of the provision is that you're an agency when acting pursuant to powers granted not by the Constitution. The APA governs proceedings in certain instances. It doesn't grant power, right? It restricts power, actually. It tells you how you have to do things. It doesn't grant you authority. So those are the kind of the two issues I'm hung up on. I can't see how you adopting the language of the APA for your proceedings makes that a law you're acting pursuant to, means you're acting pursuant to statute. Because what you are is you're acting pursuant to your own rules that just happen to incorporate the language of the statute. Do you see the distinction I'm making?
I do. Again, I think the subject matter of the proceeding, we have proceedings in licensure. I mean, and 120.60 is another specific provision provided in due process. So, and we do follow that for issuance of licenses, and that is the heart of the proceeding here today, is the decision to hold that challenge to the issuance of that license as an informal proceeding versus referring it to the Division of Administrative Hearings for a formal proceeding. And that's the sole issue on appeal.
Counsel, I'm going to ask you to assume we were to decide we don't have appellate jurisdiction under the judicial review portion of the APA. The Supreme Court has, in other contexts, talked about common law certiorari as an alternative for judicial review of agency action where there's no other way to review that agency action available. If we were to decide that we don't have appellate jurisdiction here, would there nonetheless be a common law certiorari jurisdiction? And if so, would we be required to treat this appeal as a petition for writ of certiorari under our rules of appellate procedure that tell us to treat each as the other if the circumstances warranted?
Well, Your Honor, I think, and maybe I'm hung up on this, but I think one of the elements is that there is no process available to seek the review, and so I respectfully we've put forward that process has been provided in this case through the right to have the hearing, notice of agency action, and then a hearing was held, and then we do believe that there is review available for that agency decision through the final order. Under a certiorari standard, you would also have to show that there is a sort of a fundamental error of the law such that would require the court's review. And so for those grounds, I do not think that this case would rise to the level that would be appropriate for that level of review from the court.
Let me ask you another question. I understand that procedurally here we have a dispute about the conditions placed on a permit that was issued, a conditional permit issued by the commission. Is there any procedural bar at this point, whatever happens in this case, any procedural bar to Lightsey Cattle petitioning the commission for an exemption or a variance under the procedures that are set out for that?
A procedural bar? No, Your Honor. I mean, we do have people can submit petitions. However, in this case, because of the commission's interpretation and application of the law, there would most likely be a final order issued in that same in the same vein as we've presented throughout this case, and that again, then that order would have to be subject to judicial review as well.
So if apart from this process, if Lightsey were to outside of this case were to petition for an exemption or a variance, in other words, Lightsey claims that they already have one, and that's what this fight is about. But suppose Lightsey came to you, sort of as a party not having been before the commission before and said, we'd like to create a preserve on an island. We'd like to be relieved from the requirement for a fence. Please give us a variance or an exemption. And the commission says no. The commission's decision there and its ability to even make the rule derives from the Constitution. Would there be judicial review of that decision, that no to a petition for an exemption and under the APA? In other words, would that be agency action as defined by the APA? Or would that no answer to a petition for exemption be, from the commission exercising its constitutional authority and therefore outside of the APA?
Your Honor, I believe the latter, and I was trying to think more than likely. I believe judicial review would be then provided through the circuit courts, much akin to if there is a rule challenge under 120.56.
Okay, thank you.
Does anyone have any additional questions on jurisdiction before I ask about estoppel?
No.
Okay. Counsel, assuming we have jurisdiction, I really don't see why estoppel couldn't apply. I get your argument that and the administrative judge found that there couldn't have been an exemption because legally the commission doesn't have authority to issue exemptions. But to me, that's exactly why estoppel exists, right? When you make a representation that it doesn't require that you had authority to make the representation. You just had to have made it, right? So assume we agree with you completely. 125.42 doesn't apply. The commission has no authority to grant exemptions to this, as you've argued. But nonetheless, somebody in 1987 gave Lightsey Cattle Company a piece of paper that said, we, the commission, permanently and irrevocably grant you a waiver from the fencing rule. Would that not be a representation of fact?
Your Honor, so the question is, could they have an estoppel claim? And we would say certainly if they met the elements and have alleged any facts or elicited testimony.
But they do, right? They allege you gave them a variance or a waiver. That's a representation of fact, is it not?
Yes, Your Honor. However, they have never pled any detrimental reliance or shown anything to that effect. And
So they've been putting money in this thing for 40 years. That's all over the briefs. That was all over below. That was all the witnesses they tried to put on, is that they thought they had a variance, and so they ran this place for 40 years. I mean, to say they didn't allege reliance, I don't see how you could say that. I mean,
well, Your Honor, they've operated a licensed hunting preserve on this property, and so the requirement or the condition that was placed in the license is that they then now fence that hunting preserve. And I believe much of their argument has gone toward speculating at a point in the future some burden or hardship that would occur if they are made to comply with.
okay, well, you agree they were not allowed an evidentiary hearing, correct? They were not allowed a hearing at which they could put on evidence.
Yes, it was an informal proceeding, but Your Honor, I believe if you refer to the court transcript, and particularly I'd refer to court to pages 34 and 35, and then 60 through 62, the hearing officer allowed Lightsey Cattle Company to put on any witnesses that it would like as to any matter. And he was most keen that should there arise a dispute in material fact, he would then appropriately refer to the Division of Administrative Hearings.
Counsel, that's not how I read the transcript. I mean, I think the judge said at one point, I don't think I need to hear any more witnesses. This isn't material because of how I read 125.42. But it sounds to me like you're agreeing that if the commission actually gave them a piece of paper that said, you've got a permanent irrevocable waiver, and they relied on that, that could be subject to an estoppel claim?
If they then meet the other elements, Your Honor, yes, and pled, because the estoppel in this case is used as should be as a shield, as a defense against, and in addition to the estoppel elements, this is would be a claim of equitable estoppel against the government.
Okay.
So they would need to show that they have suffered some kind of harm, detrimental reliance on that change in position that they've made due to that misstatement of fact. And I think most important for the court is that final order did address that, and they did address their equitable estoppel argument, such as it had been raised, and found that they didn't meet the elements by clear and convincing evidence, and they chose not to appeal that. The only issue on appeal, again, is having held the informal proceeding. And so it's that portion of the final order that the commission asked that this court uphold, as Lightsey has not shown any grounds for setting that aside or remanding the matter or granting a new hearing.
Judge Brownlee, Judge Ganim, any further questions?
No
No,
question.
thank you.
Okay, that case will be taken under advisement. Thank you, counsel.
Thank
Thank
you.
you.